All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Hello, everyone. I'm Chief Judge Anna Blackburn-Rixby, and welcome to the District of Columbia Court of Appeals virtual oral arguments. The COVID-19 pandemic has required the judicial system to make many adjustments to ensure continued access to justice for everyone. However, the District of Columbia Court of Appeals remains open and continues to issue opinions, hear cases, and decide matters that come before us. In order to address the concerns surrounding the public health emergency, however, the court has had to modify how it conducts these oral arguments. And we're now proceeding with oral arguments via remote video conference, which will be live streamed for public access. Court staff have made every effort to work with us, to practice, to prepare, but we know there still may be some inevitable glitches with the technology that may arise during the course of this argument. And so we'll need to exercise patience with this technology. Thank you all for your willingness to participate in this new way of moving forward. The public may view these arguments in real time at the DC Court of Appeals YouTube channel, which is on the court's website. One other thing I would ask, in order to minimize the feedback and to be able to hear the sound and hear each person most clearly, if you can try during the course of the argument to put yourself on mute when you're not speaking, but remember to unmute when you have something to say so that we can hear you. At this time, the first case for today is District of Columbia versus Bogum and Dynamic Visions Corporation. Are the parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right. I believe we'll hear first from Ms. Pittman from the District of Columbia Office of the Attorney General. Is that correct, Ms. Pittman?
Yes, Your Honor. May I ask real quickly a structural question because of the cross appeal? How would you like for us to structure that?
Well, what is your recommendation and preference? And then I'll ask the same question of counsel for Dynamic Visions and of Mr. Bongum.
Sure. My recommendation would be that the district present argument on its appeal, followed by Mr. Bongum and Dynamic Visions presenting their argument in response to the district's appeal, but then also Mr. Bongum addressing his appeal. And that then I would get up not only to rebut for the district's appeal, but then also address anything with regard to Mr. Bongum's appeal.
All right, thank you. Counsel for Dynamic Visions, could you state your name, please? And let the court know your preference as to how you'd like these arguments to proceed.
My name is Isaiah Bongum.
Mr. Bongum, I'm sorry.
I was the CEO of Dynamic Vision.
Mr. Bongum, excuse me one moment. I didn't mean to interrupt you. If I may, I'd like to hear first from the attorney for Dynamic Visions, and then I will give you an opportunity to as well. And I understand that you are not represented by counsel, so that you're representing yourself in this matter.
Yes, Your Honor.
I'll come right back to you. Thank you, sir.
All right.
Okay.
Good morning, Your Honor. Jude Iwanage on behalf of Dynamic Vision. In terms of preference, Mr. Pittman's recommendation to the court appears to be the logical way to go. So Dynamic Vision does not have any problems going forward in that matter.
Okay. Thank you, Mr. Iwanage. Mr. Bongum, the way we will proceed, I just wanted to review so that everyone is clear, as I know that you're not represented by counsel here. We're going to hear first from Ms. Pittman, who is the attorney for the DC Office of Attorney General. And then we will hear from Attorney Iwanage for Dynamic Visions. and then we will give you an opportunity to speak on your own behalf. The court may interrupt as each of you are speaking just to ask questions. That's our role here in this, during this oral argument. We're going to be asking questions directed at what we feel are the legal issues. We may not spend as much time on the factual questions and the evidence that was presented at the trial court, because our role is a little bit different here. So at this time, one last question for Mr. Wanagay and Mr. Bongum. How do you plan to divide the time, the 15-minute time that each side is allocated?
Well, Your Honor, Dynamic Vision probably will go, since we're just appellees, Dynamic Vision will go for 8 minutes, and Isaiah Bongum, since he's also a cross appellant and an appellee, and go for 7 minutes.
Okay. Thank you. All right, Ms. Pittman, are you ready to proceed?
I think I'm having problems. I'm not getting it clear, Your Honor. I'm not getting the audience well. There's an issue. I don't know why.
Thank you for letting us know that, Mr. Bongum. I think we may experience some technology glitches as we go forward. There is a feature on your device, either your laptop or your iPad, called the chat function. I don't know if you see that, but there's a way that our technicians can type messages to you that may assist in trying to resolve your technological issue. Okay. Are you able to hear me, Mr. Bongum? Okay, I think you may have
1 second.
hit, Mr. Bongum, are you able to hear us?
I'm trying to get some technician to look at the function you were talking about, because I really don't know
Okay,
great computers.
we're able to hear you very clearly, Mr. Bongum.
Okay,
So
that's good. If you can hear me, that's good. But the thing is that when you talk, sometimes it stops and I don't hear again. Chat function, can you see? You can regularize the chat function, please. Where is it? Chat function. Okay, so just sit down there. Sit down there.
okay, can you hear us now, Mr. Bongum?
Is it any problem?
Okay.
I think the internet here is not strong enough. They have a problem here in their office with internet, so that's why it's creating this
Okay.
issue. You talk, and at a certain point.
All right. We will try our best to talk slowly, because if your internet access is not strong enough, it may create a little bit of a lag time. I'm going to ask Ms. Pittman if she will begin. And again, I ask for everyone's patience as we are trying to make sure that everyone can participate and make their case before the court as best we can under these different circumstances. So Ms. Pittman, if you could proceed, please.
Thank you, Your Honor. May it please the court, I am Lucy Pittman on behalf of the District of Columbia. I would like to reserve 3 minutes for rebuttal. The Supreme Court 74 years ago set forth a framework for considering wage claims. Employers are required to maintain the most probative evidence with payroll and wage records. And when it fails to produce those records, the employee's minimal burden is met with sufficient evidence to establish a violation as a matter of just and reasonable inference. Sufficient evidence is not perfect evidence. It's not even direct evidence for every single employee with a claim. Instead, it is based on a representative sample, summaries from the government, and just and reasonable inferences. The district's evidence in this case was textbook. It's like the typical Fair Labor Standard Act wage claim. There were a large number of claimants. Here there were 136. 49 of those, a subset, testified as a representative sample. Those 49 claimants established a pattern and practice by Dynamic Visions of not paying owed wages.
Ms. Pittman,
Yes.
Ms. Pittman, can I ask you
may
a
I-
question?
may I
about
ask a
the-
question?
Yes.
Go ahead, Judge Thompson.
Oh, no, sorry. Go ahead, Chief. I didn't realize you were speaking.
Yes, Ms. Pittman, I was going to ask you if you could talk a little bit more about what legal standard or what factors help us determine whether or not this was a representative class. I noticed that the statute has provisions at 32-1308 A1C for class actions and for collective actions, and this was neither.
That's right.
Can it still be representative if it was not a collective action or a class action, and what makes it representative?
Sure. So the provision that you're relying on in DC Code 32-1308 is actually a new provision. That was not the provision when this act or when this case was brought to the Superior Court. And so we're actually relying on the 2010 version, which does not have the collective or the class action provisions. But I don't think that that's all that relevant, because when you look at the Fair Labor Standard Act cases, only one that we cited in our case, Tyson's Foods, was a collective action. The rest of them were brought in a very similar way as to how the district brought this case, which was on behalf of a large group of claimants with a subset of those claimants testifying. And in fact, here we had a larger subset than what you find in many of the other cases.
But what makes this subset quantitatively, in terms of number, representative, but more importantly, qualitatively? What characteristics does the trial court need to look for and find in order to determine? In other words, is it enough for you to say that we think this is representative and therefore is, or doesn't the trial judge have to make some specific findings about why the group that you chose to testify in the trial below was representative?
Sure. I don't see anything in the case law that specifies a quantitative number. There are some cases as low as 2.5% of the employees were adequate for a representative class. I think the Burger King case that I cited in the brief, where there were multiple Burger King locations, one person from each location may have testified. And then there's other examples where you don't even have that. I think that the main thrust of what you see in the case law is, are these similarly situated employees? And here, where you have 133 of the 136 claimants were in fact home health care aides, and were similarly situated in that regard. 49, 1/3 of the claimants, 47 of them were home health care aides, certainly meets the representative standards that you see in some of these cases. Mount Clemens, the Supreme Court case itself, was based on 7 employees for 300, representing 300. And so the main goal here is to make sure that you've got similarly situated individuals. And the court's findings here show that we have similarly situated individuals. The court explained how consistent their testimony was, even though as home health care aides, they worked independently in individuals' homes and didn't even know one another. And in fact, it's very similar to the McLaughlin v. Dial America case that we cited in our brief, where those were home researchers and they also did not know each other. And yet the consistency of their testimony was such that the court could rely on that to draw the reasonable and just inferences that are permitted under the act.
But did the court, was the trial court specifically asked to determine whether or not those employees who did not testify before the court were adequately represented by the ones who did testify? Was that issue squarely before the trial judge? Because as I read the record, it's not clear to me that that was the focus below. I think the trial judge was concerned that those employees that didn't testify, their written claim forms were not sufficient because he determined they were hearsay. Did you make the argument to the trial judge that you're making to us, in other words, that those employees who did testify are adequately representative of the entire group because of the nature of the work that they did?
Sure. And the Superior Court relied on many of the same cases, or cited some of the same cases that I cited. The April 19th argument, and I can refer to that transcript, specifically has arguments with regard to Mount Clemens and the post-trial brief as well. And so the court was certainly well aware of this case law that representative testimony is adequate to establish the employee's burden. And that what we find here was the error that occurred, was not recognizing that it was the representative testimony that met the district's burden in this case. And that the claim forms, while certain aspects of it may be hearsay, that's not relevant, given, for example, the holding in Brock v. Cito, as well as Hodgins v. Humphreys, which indicated that these forms, while not being brought in for the truth of the matter asserted, these summaries that the compliance officers testified to in those cases, they were still relevant testimony with regard to the claim.
For what purpose, Ms. Pittman? If they're not, and counsel in this case did not seek to introduce them for a substantive evidence. So what would be the probative value of the claim forms that were filed with the, that Ms. Hood spoke about? What would they be useful for?
They're useful for two reasons. They're useful for damages, which the case law is clear that when you consider the wage damages, estimates and summaries, even when those summaries are based on hearsay testimony, are admissible and can be used for the calculation of damages. So they are useful in that regard. They're also...
I'm sorry, because this is something that kind of hung up the trial judge, and I guess I'm concerned about as well. When you say that they're relevant to damages, that would be for the truth of the matter asserted in the form, right? I worked so many hours.
They're useful in that they're estimates or summaries of the hours that they worked but were not paid. And for that, I can refer to Brock v. Cito, where the court there was reversed. The trial court was reversed because they would not allow these computations to be admitted. They were considered inadmissible because of the hearsay. And there the Ninth Circuit reversed, saying that no, that's how these damages are calculated in wage claims, that they can be estimates, and that the compliance officer's testimony needed to be brought in for that purpose. The claim forms also serve another purpose, which is that attached to many of them is proof that these individuals were employees of Dynamic Visions. There are pay stubs from Dynamic Visions. There are timesheets from Dynamic Visions, as well as from the sham companies, CareFirst and Alpha Healthcare. And all of those forms also bolster the representative testimony that support that the wage theft claim in this case.
But those claim forms also would have established that some of the non-testifying claimants were employees.
I think it certainly supports that, because Not only did these employees sign under penalty of perjury that they were employees of Dynamic Visions, but they also attached to their claim forms various supporting documents, like a pay stub from Dynamic Visions.
No, I understand that. All I'm saying is, and that would relate directly to the non-testifying claimants.
That's right. That's right. And so it just meant, I'm sorry.
I wanted to ask you, Ms. Pittman, I wanted to follow up on Judge Blackman-Rigsby's question, the Chief Judge's question about the representative group. You mentioned that in the Burger King case, for example, there was a representative group because there was one employee per location. That may not be the exact number, but it's, you know, someone from each location. What, if anything, does the record here reveal about how the testifying individuals were actually representative of the group? And I want to preface my question with just this comment. This court has had before it fairly recently some cases involving home health agencies where there were allegations of fraudulent billing. That is not this case, so I'm not suggesting this involves that. But the records in those cases showed that a number of the individuals employed in the industry came from other countries, sometimes returned to their countries for visits of a couple of weeks, sometimes had other individuals working for them on particular days when they were out of the country. It seems to be a unique industry. It is not like the Mount Clemens case where everybody was kind of a piece worker who showed up close to starting time and left close to quitting time after, you know, clocking in and clocking out. So in my mind, it just raised the question of, in an industry like this, what more can you say about what made the testifying individuals a representative of the others, and what does the record reveal about who was chosen to be a testifying individual, to the extent you can say? Do you understand the question?
I do, and I'm going to address the last part first, which is I don't know that the record reflects how these individuals were selected, but I don't believe that that's particularly determinative here, where you have 47 of the representative witnesses representing 133 home health care aides. And while I recognize that home health care aides, as the court recognized, work individually, they don't necessarily know each other. They work in the home of a patient. And so it isn't like Mount Clemens where it is a matter of punching a time clock. That doesn't then make the representative testimony any, less probative here. And I would instead turn the court to McLaughlin v. Dial America, where these were home researchers, also working independently, also keeping track of their hours in that regard, as well as Herman v. Hector Transport Inc. These were truck drivers who worked independently and yet didn't necessarily know each other, and yet their representative testimony supported the claim that they were making for the lost wages. And here we have specific findings from the Superior Court that despite the fact that these individuals did not know each other and did not work together, there was such consistency in the way in which they testified about how they began working, the training they received, how the patients were assigned to them, the supervision that they received from Dynamic Visions employees, and how the timesheets were then submitted and payments were made. And all of those things are consistent for any employee, whether it was a testifying employee or non-testifying employee, in terms of the way in which Dynamic Visions ran its operations. All of that was consistent, and the court credited all of that testimony as being credible and consistent, despite the fact that these individuals did not know each other, and in some instances did not speak the same language as each other.
The court specifically credited that for the non-testifying employees, even though he deemed much of their affidavits or their claim forms to be inadmissible.
So it wasn't credited. I don't know that there is an explicit answer for that in terms of the judge did not credit that.
Here's what the
regarding
issue that
non-testifying.
I'm sorry to interrupt.
It's-
The issue that I'm grappling with is how do we make the connection, or can we do it? I guess my view is that doesn't this need to be remanded for the trial judge to make specific findings, the very findings that you're asking us to be able to conclude from the record? It's not clear, or maybe you can make it clearer to us in your argument today, that the trial judge made that connection and said, yes, he clearly credited virtually all the testifying witnesses and agreed that they were entitled to have wages reimbursed that were wrongfully withheld. But I don't see that he really said much about the non-testifying witnesses. And it seems like you're asking us to conclude as a matter of law that the testifying witnesses represented and were representative of everyone, even if they didn't testify. And help me understand how we can do that, because it seems to me this may need to be an issue that is clearly within the realm of what the trial court should do. And when I asked earlier about whether the argument or the request was specifically made to the trial judge, we want you to designate all the witnesses who didn't testify, but who filed claims as part of the 136. We want you to conclude, based on all the evidence from those who are testifying, that those who testified are representative of everyone. Doesn't the trial court in the first instance have to say, as I look at many of the cases that you cited to us, there was a determination first by the trial court that either those who testified were representative or they weren't representative. And then that decision was then appealed to our court, or to an appellate court, because these were federal cases, to an appellate court to review the correctness of the trial judge's determination as to whether or not those witnesses who testified were in fact representative of the whole group.
Sure. I think I understand what you're getting at, and which is that there does need to be a remand in this case. And that is because the Superior Court did not apply the Mount Clemens burden shifting appropriately. In the cases that we cite, it's less about whether it was representative testimony and more about whether a pattern and practice was established through that testimony. And here we do have adequate findings from the Superior Court that the pattern and practice is that Dynamic Visions hired home healthcare aides, and at some point, largely in 2009 and 2010, stopped paying them. And that pattern and practice testimony, which is unrebutted, and I also think that that's key. In all of these cases, there has to be rebuttal from the employer with precision. And here we have no rebuttal, let alone rebuttal with any sort of precision. And so what we're asking is that it get remanded to the trial court on this record where you have pattern and practice evidence, pattern and practice findings. The court can enter liability for the non-testifying employees. What needs, I think, further development and factual development then is what would the damages then be awarded based upon the claim forms that exist? Because there were, as the court noted, the occasional error and mathematical error and things like that. Those are things that certainly need to be considered on remand. But the liability itself, the pattern and practice testimony and the findings from the court of that are sufficient to coupled with the fact that there is nothing in rebuttal, and that burden is on the employer, is sufficient to enter liability for those non-testifying employees.
For this court to enter a finding of liability, or for the trial court on remand to enter a finding of liability?
I think it's remand with instructions to enter liability. and then further proceedings on damages. I do see that my time is up and I don't want to take advantage of the court's time this morning, but I do want to make sure that I'm responsive to questions.
Well, we will come back to you as you will have time on rebuttal. You'll reserve some time for rebuttal. So let's hear now from Mr. Iwanage, counsel for Dynamic Visions. Thank you, Ms. Pittman.
Good morning, Your Honors. May it please the court, Judy Iwanage on behalf of the appellee Dynamic Visions. This appeal, I don't see any basis for a remand for the trial court to go into the records to clear what is already clear from the records of the case. As Ms. Pittman tried to answer in response to one of the judge's questions regarding what do the claims form prove, she clearly said they go to damages. We don't get to damages until we've dealt with the issue of liability. The trial judge correctly found that there was insufficient evidence from the district to determine liability for the non-testifying witnesses. The government at no point, that the district at no point in the trial attempt to show that the testifying witnesses are in any way similarly situated or will form a representative class for the non-testifying witnesses. In all the cases that the district cited in its brief, all of them are clearly distinguishable from the facts of this case. In those cases, it was—
Mr. Iwanage, may I interrupt you briefly with a question? You argue that the Office of the Attorney General did not try to prove at the trial court level that those who testified represented the entire group. Now the trial judge did make a finding, well, not a finding, an inference, an unfavorable inference against Dynamic Visions for failing in discovery and otherwise to provide its employment records for each of the employees. Doesn't that adverse inference really extensively at least prove their prima facie case in the absence of any other rebuttal evidence from you or Dynamic Visions?
That would be correct, Your Honor, because the cases even cited by the district, when you look at those cases, the inference—
Did you say it would be correct or incorrect?
Incorrect. I would disagree with the court, that will prove liability. That may go to the issue of damages when it comes to computation. If the records do not show that this person worked X number of hours or Y number of hours, but at least the initial prima facie case has to be presented by the district to show that these individuals are employees, or at least that the individuals—
Well, but Mr. Iwanage, the whole key holding in the Mount Clemens case was to address cases like this, where the employer failed or refused to provide the accurate employee payroll records, which are exclusively within the control of the employer. And so Mount Clemens essentially said that the employer can't fail to turn over, withhold, or fail to keep employment payroll records and then put the unreasonable burden on the employee to try to show that they were not properly paid. And so Mount Clemens created a burden shifting so that all that the district government had to do was put forth a prima facie case, which was greatly aided by the court's adverse finding against Dynamic Visions for failing to turn over the payroll records. That seems to me is sufficient for the initial prima facie showing that they were not properly paid. Then it was on Dynamic Visions to come forward with evidence that would uniquely be within the employer's possession to show that they were paid. And that part didn't happen.
Well, Your Honor, the court, Your Honor, you're moving to the next step which is whether they were not paid. As an initial matter, the first
No,
element.
no, they already established that prima facie, at prima facie level, that they were not paid. And then the burden under Mount Clemens shifts to the employer to show evidence contradicting that. And so there was enough, as I read this record, for the burden to have at least shifted to the employer to put forth some showing of inaccuracies in the employees' statements or affidavits or other evidence that the Attorney General produced. And that didn't happen here.
Well, Your Honor,
That opportunity was made available at trial, wasn't it?
no, Your Honor, I'll disagree with that position because the court is going to whether they were paid or not paid. We have to first of all cross the first step, which is whether they were employees. As the trial court found that there was insufficient evidence in the record to even determine or make the call for the non-testifying witnesses, whether they
are you talking about the non-testifying?
Yes, I'm talking about the non-testifying, Your Honor. But that's the crux of the district appeal, that the non-testifying witnesses should have the court should have found liability for them. But in order to get to whether they were paid wages, you determine if they are employees. And the court made a finding that there was was introduced was hearsay evidence, and there was nothing presented by the district to show that these individuals are actually employees before we even get to determine whether they were paid or not paid. So the government.
Ms. Pittman just told us that among the documents, supporting documents with the claim forms were payroll stubs that apparently would have originated from the employer, right? That would have established that some of the non-testifying defendants were employees of Dynamic Vision.
Well, Your Honor, as the trial court said, going into those documents without the court will be the court guessing on who's an employee and who's not. The individual.
I'm sorry, why would it be guessing if it can be shown, if the district can present a document from the employer, a payroll stub that has the name of a non-testifying claimant, why would that not be probative evidence of the fact that that person was in fact an employee?
Well, Your Honor, what we had mainly and what Ms. Hood testified about and what she could testify to was the claim forms that are actually filled, not the pay stub, but the claim forms. Anybody can fill a claim form and say, I work for Microsoft.
I'm sorry, I was talking about a payroll stub, a paycheck stub that comes from the employer, right?
Well, you know, if a payroll stub or pay stub comes from an employer, that may be. However, what we have for the non-testifying, which was presented and what the court said it was going to look at it for just to show that they filed claims, are the claim forms, not the individual or any specific pay stub. There were those specific pay stubs which the government attempted to introduce through any individual that testified. What Ms. Hood testified about were the claim forms. So the court talking about guessing will be going in to determine, okay, what may be a pay stub here, what may be a pay stub there. Ms. Hood's testimony was about what the employees or the alleged employees told her.
But are we talking now in any event about specific claims? I mean, that you would have to establish with respect to a specific claimant, employment, and then the question of how much in damages. But in terms of whether the district, which is bringing this case on behalf of over 100 people, 136 people, whether it has established first a prima facie case that there has been a violation, why aren't we beyond that? And then what we're really talking about now here is the next step of a claimant by claimant determination of damages.
Well, you know, we can't be beyond that because we've not, first of all, the evidence has not determined whether these are individuals who are similarly situated. There's case law that determines how the court, can say who is similarly situated. So regardless of whether there's an adverse influence or not, if the government was trying to present its case as a collective action or to have these individuals come in as representatives of the non-testifying witness. The government was supposed to use that
Depends,
framework.
it's similarly situated as to what? For example, as to what? The trial court credited a number of the testifying claimants, commented on how similar the testimony was, even though they didn't know each other, spoke different languages and all the rest, and said, and on the basis of that found that Dynamic Visions was the employer, right?
Well, for the testifying witnesses, yes, Your Honor.
Okay, right, as opposed to Alpha or Care First, right? Said, no, it's Dynamic Visions because gave credited kind of how things worked, who was assigning the work, where they went, when they were paid or not paid. In other words, it's this pattern and practice that Ms. Pittman was talking about, that there were certain common elements that kept coming up that established that Dynamic Visions operated in a certain way that denied payment to its workers,
Well, Your Honor, that's
generally
correct.
speaking.
Well, Your Honor, pattern and practice is not the determination or the test used by the court to determine if employees are similarly situated. In case law, and most of the cases cited by Ms. Pittman, there are three factors that the court looks at. The court looks at the factual and employment setting of the individual plaintiff. In this case, just like the Chief Judge recognized that this area of employment that for the home health aid is a unique area. There is not a one size fits all, unlike the cases of like Claremont and other cases relied on by the district, whereby the individuals or the issue at hand was either they did not pay them wages while they were on break, or they didn't pay them wages for the time that they clocked in and had to change and walk to the position where they're going. Here, the reason or the basis for the non-payment are unique to each individual. It wasn't that there was a particular motive to not pay them for a particular reason. Even the testifying witnesses gave different reasons where they were not paid. Some of the issues that were before the court had to do with people who had to buy uniforms. Some testified that some pay was deducted from their payment. So it wasn't a unique situation whereby you can determine, okay, there was 30 minutes of pay that was deducted from all of them. So these people are similarly situated. And that's why I come to that point whereby
well, but Mr. Iwanage, the similarly situated in our case law also applies to the nature of the business. This is one company, Dynamic Visions, that exists to provide home health care aids to individuals. And we're talking about employees, for the most part, who were engaged in that work and who are claiming that their employer systematically, for a variety of reasons, failed to pay them or underpaid them and withheld their proper wages. None of our cases, as I read them, say that each case has to be identical and each failure to pay or wage withholding has to be identical as to amount and as to method. So I think that as I read the cases like the Mount Clemens case and others, the reason those cases exist is to prevent employers from sitting back silently with all the records and information about payments and salary and wages, while a large group of employees or even a small number of employees claim that they haven't been paid and put forward an affidavit, file a claim, state the reasons and the amounts they believe they weren't paid. When that happens, that's a sufficient basis here. And there was no challenge from Dynamic Visions that those employees who didn't testify, but whose claim forms were available and in evidence, were not employees. There's nothing rebutting their claim that they worked for Dynamic Visions. That's sufficient, I think, for a prima facie showing and sufficient to then shift the burden to Dynamic Visions as the employer to either say, no, they didn't work for us and here's our records, or they worked for us, but we paid them fully and here are our records. And Dynamic Visions didn't do either of those things.
Well, Your Honor, in the answer to the complaint, Dynamic Vision denied that the individual employees. At the trial, there was no basis or any reason for Dynamic Vision to deal with those non-testifying witnesses because the court already said that it wasn't going to admit the claim forms for substantive purpose, that it was coming as non-hearsay just to show that they filed a claim. So there was nothing before the trial court for even Dynamic Vision because the government or the district at no point attempted to do anything with the non-testifying witnesses besides trying to introduce the claim forms as substantive evidence, which the court already denied. So there was nothing for Dynamic Vision to rebut because they rebutted and cross-examined all the testifying witnesses that showed up. But for the non-testifying, there was nothing for Dynamic Vision to do because it wasn't before the court. And as the court found,
with Dynamic Visions, what would be the basis? You've heard us talk about the potential need to remand this case to the trial court to make a finding that wasn't made, and under the law as we see it, perhaps should have been made, about whether or not those employees who testified were representative of the non-testifying employees. Why would that not be an appropriate step at this juncture?
well, Your Honor, it would be an appropriate step at this juncture because that is like having the district do what it didn't do the first time. It was their claim to prove. They have the burden of proof to present that the individuals that were testifying were representative of the non-testifying. They didn't do that. They've already lost that chance. They had that bite at the apple, which they didn't take. So having the case remanded for them to now do what they didn't do is like giving them a bite at an apple that they had in the first place that they didn't use. They brought the case. They knew where the individuals were. The telling point also, Your Honor, is that the district knew ahead of time that these individuals were supposed to be produced. They filed a motion in limine, and the court said, you have not established that these people are similarly situated. So it is for you to show when you get to trial, if they are, and the court will make a call at that point. They did it at the trial. So remanding it now for them to come and start showing, they don't have the witness. And that was probably the reason why they didn't bring them. So
well, no, as a matter of law, though, our cases, as we've been discussing, do not require in these types of cases that every single employee in a group must testify if a sufficient number of the employees have testified and they are representative. And that's the legal question that we're grappling with here. I see that your time is, I know we've taken a lot of your time with questions, Mr. Iwanage, and I know that you have also requested some time for a rebuttal, and we will certainly permit that. But you were going to be splitting your time with Mr. Bongum, and let's give him an opportunity to speak, and you'll have a moment to rebut as well. Thank you for your argument, Mr. Iwanage.
thank you.
Mr. Bongum? Can you hear us, Mr. Bongum?
Good morning, Your Honor. Yes, Your Honor. Good morning, Your Honor.
Good morning. Did you want
Good
to
morning,
say?
Your Honor. No, just I want to be hearing what you are saying because you speak and it stops for sometimes. That's the issue, yeah.
This is your opportunity to say a few words about your case if you'd like to at this point. You have a few minutes to do so. And so we are listening to you.
Yes, Your Honor. I was the director of Dynamic Vision at the time, and we had a problem. We were closed down by the district. And after that, a matter was instituted. But the issue here is that Mrs. Hood, who is a specialist in wages, normally the procedure allowed her to notify me that there were some employees claiming that we did not pay them. Mrs. Wood never sent any letter to notify me. And she said that the rules allows her to subpoena me if I do not collaborate. And she never subpoenaed me. And what happened here is that the documents that she received, that she was supposed to call me so that we have a face-to-face, never took place. And the documents that they tendered to her were not documents from Dynamic Vision, because you'll find out that all the checks that were put in the file were from CareFirst and Alpha. They are entities, companies that were duly registered in DC. So the district never made any attempt to bring any of these individuals to court, even though they are the ones that employed this employee, because the individuals had escaped. So, and they found out that it was just right to bring a check that came from Alpha, CareFirst, and say it is from Dynamic Vision. And they brought some adventurer, Mr. Jonka, whom the judge realized that he was lying and told him that he was lying, that he cannot take his testimony in consideration, but turn around and use his testimony in writing his decision. However, these cases, most of them date from 2006. And by the time this matter came up, there was already more than 3, 7, 4, 7, 8 years. So it showed that the cases that came up were, first of all, tampered. There was there was already limitation. So they were not supposed to bring these cases. And I challenge you that they had reached the limitation and the judge threw it down. And continue with the matter up to this moment. And the issue here is that these individuals did not work for Dynamic Vision. And if they had worked for Dynamic Vision, all our documents were seized by FBI up to today. Every paper on the November 2008, they searched everything. So even if they were Dynamic Visions, we would have gone maybe to FBI to ask them to produce, because we could not produce documents even for people who did not work for us. Somebody works for Alpha Home Health Care. How do you expect Dynamic Vision to have the paperwork of Alpha Home Health Care? And I am here because I am honorable. I'm sure those people who own Alpha and First Care are no longer in the country, and that's why the district cannot get them, and they would not ask me to pay for money that was supposed to be paid by a different company. And some of these companies even owed my own money. I cannot see them to collect my money or not. So actually what is happening now is very difficult, but I am surprised that Mrs. Wood, who is a long-time specialist, will institute a case like this, will never send me a notice.
All right, Mr. Bongum.
That some employees were.
Mr. Bongum, forgive me for interrupting you. Can you hear us now?
Yes,
I wanted to see if either of my colleagues had any questions for you. As I mentioned, I know that some of the arguments that you're making to us today were issues that you raised with the trial court below, and we hear your concerns and your comments. I just wanted to check and see with my colleagues if there were questions for you.
Thank you. I'm listening, Your Honor, for the question.
I don't have any questions.
Okay, so there's no questions at this time, but thank you very much for your presence today and for your arguments before this court. At this time, I believe Ms. Pittman has reserved a few minutes for rebuttal.
Thank you, Your Honor. I want to return to a topic that was covered with Counsel for Dynamic Visions, which is how do you determine if individuals are similarly situated? And I can refer the court to the DeSito case, which says that usually an employee can only represent other employees if they perform substantially similar work. Here, in that case, there was an attempt to have one employee represent 244 individuals with different jobs. And the court explained, no, that you can have a fairly low number, but they do need to have the same job. And here we had 47 individuals who are home health care aides who testified for a total of 133 home health care aides in this case. And there hasn't been any showing on the part of the employer that their work was not similar, and that they didn't perform similar work. In fact, the testimony and the findings from the court was to the contrary, that their work was very similar, and everything about Dynamic Visions and the process of their payment, et cetera, was similar. I also want to turn to a couple of quick things. I think that the Superior Court was completely correct in its assessment that First Care and Alpha Healthcare are sham companies of Dynamic Visions, and we haven't seen or heard anything to call into question the court's findings in that regard. And so the court in making those findings relied upon those 49 employees who testified, and every single one of them testified regardless of what their pay stub may have said, or regardless of which pay sheet they filled out, they were employees of Dynamic Visions.
Ms. Pittman, so I just wanted to clarify that for the non-testifying witnesses, what was the evidence before the court that constituted a prima facie showing that they were in fact employees of Dynamic Visions?
Sure, it's the same as any violation of a wage claim, which is the representative sample testimony establishing the prima facie case. Employment is one element. On that end, I'd actually point out that, you know, Dynamic
So just to be clear, the district is relying on the representative sample to prove that those remaining employees who did not testify were in fact employees of Dynamic Visions. There was no direct evidence before the court about the non-testifying witnesses that they were employees of Dynamic Visions. And your argument is, well, I guess to confirm that first. And then if not, if there was no direct evidence with respect to the non-testifying employees that they were in fact employees, your argument is that they're, under our law, there did not need to be, because the evidence from the representative employees was sufficient.
There wasn't, I will agree with you, Chief Judge, that there wasn't direct evidence for every single non-testifying employee that they were employees. I do not see anything in the case law to indicate the Mount Clemens burden shifting would apply differently to that element of a wage claim as opposed to any of the other elements. I also think that we have to look at how Dynamic Visions defended this case. They defended the case by saying that none of the employees were employees. Well, we know that's just not true, because the court credited 49 of them who testified credibly and consistently that they were in fact employees of Dynamic Visions. And that Mr. Bonham continues to take the position that regardless of the pay stubs and regardless of the court's findings, that they're not employees. And so we know that that is just simply not true. And then we have, in addition, what I had mentioned and Judge Ruiz referred to, which is for those non-testifying employees, many of them do have supporting records like pay stubs and timesheets that show that they were employees of Dynamic Visions. And so,
but those were not admitted into evidence, those pay stubs and supporting documents.
They were not admitted as into evidence for that purpose, which was an error on the part of the court. And Brock v. Cito, I think, directly explains why that was reversible error. And then the final thing, which I think is important, I think it's almost a cherry on top in this case, is the adverse inference. The court explicitly found here that had the records that Dynamic Visions was required to maintain, had they maintained them, it would have shown that these individuals were employees. And there's nothing in the record to indicate why the employees who testified get the benefit of that adverse inference, whereas the individuals who did not testify do not get that benefit. And when I say it's a cherry on top, it's not something you find in most Fair Labor Standard Act cases. They don't have, in addition to all of the pattern and practice evidence and representative testimony, an adverse inference. And that's something that is in addition here to the district's proof.
Ms. Pittman, so I take it you agree that even though the representative testimony is enough to establish a prima facie case, which shifts the burden, when it comes down to actually awarding back pay, there has to be a determination as to each claimant that the person was an employee?
No.
No?
I believe that there does need to be a finding of that nature. I think that the representative testimony is sufficient to put the burden on the employer, which they didn't rebut.
But the representative testimony and the trial court's findings go to who the employer was, right? That it was Dynamic Visions, that it was Mr. Bongham. But then you still have to say that the employee, in fact, was an employee, right? Was that the employee performed work. What is to prevent someone who's just, who just walked in from putting in a claim? And I might mention that in Mount Clemens, the Supreme Court assumed that the employee has proved that he has performed work and has not been paid in accordance with the statute. So it said the fact, the damage is therefore certain. I worked, I wasn't paid. And then the uncertainty lies only in the amount of the damages arising from the statutory violation by the employees. And then said it is enough under these circumstances if there is a basis for a reasonable inference as to the extent of the damages, which is what you say is a next step that has not yet happened, right? The extent of the damages of those non-testifying claimants. But there still has to be this established that I performed work, I wasn't paid.
That's right. But the way in which Mount Clemens has been applied over the last 7 decades has been that you don't need direct evidence of a violation for every single individual employee. And so the Reich case, violations of the act may be inferred by the court, and that was applying Mount Clemens. And in particular, they applied Mount Clemens in that case very specifically to the violations phase and then later to the damages phase. It applies to both. And it is clear that on these cases, and McLaughlin would be another example, that violations may be inferred based upon the pattern testimony. And so it isn't
violation in terms of non-payment. But what about the premise, the basic premise, I did work. I was an employee and I did work.
Yeah, that's my question too, Ms. Pittman. As Judge Ruiz puts it, what stops somebody from showing up and saying, I worked for them too, they didn't pay me? If the burden shifts to them, how do they show they never employed me? No records of mine were submitted. I'm just claiming that I was an employee, and they can't point to something that would say I never was. I mean, they could point to something that shows that I worked, but if I didn't, they won't have a record of me. So how do we get over that hurdle here?
I think there's a couple of things that prevent someone from just walking off the street and saying that I was an employee. One of which is the investigation process that is done by the Office of Wage and Hour. The second is that the claim forms are sworn under penalty of perjury or declared under penalty of perjury. The third is that attached to those records are Dynamic Vision's Alpha House and First Home Care pay stubs and timesheets and other supporting documents. And I think also most importantly is that Dynamic Visions has produced nothing in rebuttal. I disagree that payroll records here wouldn't be relevant. If they had brought payroll records in and it said, here were our list of employees, and there was a name of one of the claimants that wasn't on those records, that would be highly probative. But here we don't have that. We also just don't have that they're saying one or two of these employees weren't employees. They were saying universally they weren't employees. And we just know that that's not true given the way in which this case was tried. 49 of them testified they were employees. The court did not find any problems with the claim forms with regard to the pay stubs and that level of proof of their employment. And then, as I said, we also have the adverse inference. Had they brought these records in, it would have shown that they were employees. So I feel like the concerns that you have of someone coming off the street, I completely understand them, but there are a number of protections in this case and the way in which these cases are tried that prevent that from happening.
And in that sense, the trial court committed error in not allowing the claim, Ms. Hood's testimony and the claim forms to come in for some purposes. Because the Brock case, again, also talks about it was only allowed for the limited to showing the methodology of the computations and not the veracity of the employee statements. That's what the Ninth Circuit says, right?
That's for damages. That's right. And so in a couple of these cases where there were hearsay issues, the court indicated that they weren't coming in necessarily for the truth of the matter asserted, but they were coming in for these other purposes. Here, the trial court limited the purpose too much in not recognizing that these records included, for example, these pay stubs and other documents. But I think most importantly is that before you even get to that, the burden had already shifted to the employer, and here they did not produce anything to reflect these individuals were not employees.
So how do you see this proceeding on remand? I mean, what actually happens? Does the trial judge have to sit down and make an individual claimant by claimant determination, look at what documents there are with respect to each one? Or can a trial judge just take even I assume that there aren't documents for everyone.
No.
Just take some and come up with some, rough average kind of back pay award.
So I think that there's a couple of things that I think need to occur on remand. As I mentioned earlier, I think that a liability determination can be made for the non-testifying employees with the finding that the district met its burden and that the employer failed to rebut the district's case for violations purposes. And there's sufficient case law to say that you can then infer the violations for the non-testifying employees. I do think that there needs to be further proceedings on the amount of damages. I think a couple of things could occur. I think that the claim forms can go through those and treat them as that there is more than sufficient to indicate that that estimates are an acceptable way to determine damages, even if at times they are somewhat generous. And there, I think it's the Reich case that refers to sometimes the award might be generous. And the reason for that is because that's what happens when the employer who bears the lion's share of the burden doesn't meet their burden. And so there will need to be additional proceedings, as I mentioned, on how to determine and calculate damages.
Right. Thank you, Ms. Pittman. Is there any final word? I was taking you a bit over your time, but I'd like to give Mr. Wanagay an opportunity for rebuttal as well.
No, thank you, Your Honor. I appreciate the time.
Actually, let me Okay, Mr. Wanage, are you ready to proceed with a brief rebuttal?
Yes, Your Honor. With regards to the adverse influence, which Pittman references and which the court referenced, even the event that Dynamic Vision was found to not have kept the records, the question becomes, under the statute requiring them to keep the records for 3 years, 32 DC code 32-1008, also DC code 32-1306 D1, and DC code 32-1331.2A, where the employer is supposed to keep the records for 3 years. However, even though the court made a finding, adverse finding that the records were not kept, however, the court missed one step, because even if the court was supposed to do it, under 32-1306A2B, it clearly states that no employer may be found to be in violation of that subparagraph that requires them to keep the records for 3 years if an opportunity was not given by the mayor to the employer to challenge the Attorney General's demand before a judge or an administrative law judge. In this case, Ms. Hood did not say that Mr. Bongham was subpoenaed to provide, or that Dynamic Vision was subpoenaed to provide the record. So there was no opportunity even given to Dynamic Vision to challenge those records if they were kept within 3 years. That did not happen here. So before we even get to the point of the adverse influence, there was supposed to be a determination that they had the opportunity and failed to do it. Just that you did not disclose or produce something in discovery in a case that came up like 5 or 7 years after your obligation under the statute was due. The statute required them to keep it for 3 years. At the time this case was brought, just like Mr. Bongham mentioned, that a lot of the issues that were raised had already, the statute had run, which was raised and preserved by Dynamic Vision, because some of these claims accrued in 2006, 2007, and this case was not filed until sometime in 2012. And at that point, the statute had run, and the obligation to even keep those records had also already expired. So the fact that the court said, okay, they didn't disclose this, you cannot produce what you don't have. Just like Ms. Pittman is making it sound like Dynamic Vision can prove the negative. Just like Judge correctly asked them, how do you report or prove the negative? If somebody says, I'm not your employer, there is no way to prove that the person is the employer if you don't have records. You can only have records of an employee. You cannot have records of non-employee. So how will Dynamic Vision produce records to show that Miss A that walks up the street is not an employee? That cannot happen. So in this case, Dynamic Vision is put in a place where there are certain things that they cannot report because there is nothing to show. So specifically, as it goes to the issue of liability, for most of those non-testifying witnesses, there is nothing for the court to have relied on. And even if this case were to be remanded, there won't be enough for the court to rely on to cross that threshold to show that they were employees and then they worked those hours. Even the testifying witnesses, the court found some of their testimony not to be credible with regards to the time that they said they worked or what they worked. Just like the individual that claimed that she worked for 48 hours in 2 days, which is plainly impossible. The court did not credit it. So for some of those witnesses, we will run into that same situation. So having to do an approximation like they did in Clement's case, clearly in that position, there were some approximations that could be done. But in a case like this where it wasn't a uniform thing, neither were the employees, even the testifying ones, they didn't have like a common number of hours or claims that you could say, okay, we could stretch it to somebody else or a non-testifying employee. That is not in this case. So even if this case were to be remanded, the trial court will be left to speculate as to a whole lot of issues like Ms. Pittman is suggesting, that the court can either be generous, do an approximation in this way or that way. It won't be there before the court. So it will turn out to be some exercise that may end up in futility. And that was why the trial judge said, I cannot guess, I'll be made to guess if I have to do this.
All right, Mr. Wanage, thank you very much for your comments. Mr. Bongham, I'll give you a very brief moment if you have any final words to say.
Yes, Your Honor. I will thank the court for giving me this opportunity, and I will tell the court that if I was asked to produce the possibility, because these individuals did not work for me, so how can I produce documents for people who have never worked for me? I want the court to look at this and to see that these issues started in 0506. And it came limitation, and it was not even easy after 8 years to produce to the court. And I think that this is my submission, and I want the court to look at it and see that it was impossible for the documents they are asking for me, and this case had already reached the statute of limitation more than 6-7 years ago. Thank you, Your Honor.
Thank you, Mr. Bongum, and we have received and reviewed your submission along with the other briefs and submissions of each of the other parties. I'd like to thank all counsel, Ms. Pittman and Mr. Wanagay, and Mr. Bongum, thank you. I understand that you have been representing yourself in this proceeding. We thank you for your participation, and we will take this matter under advisement. And I believe we're going to transition now to our second case, and I'm going to ask our courtroom clerk, Mr. Green, to guide us through that transition to the second case, please.
Yes, Your Honor. Okay, counsel, if you could
Thank you,
exit
Honor.
out for the first case, thank you.
Okay, so I think we will need Mr. Bongum to officially exit from the court at this portion. I see that his computer is still on and logged in at this time. Okay, thank you. Are counsel present and ready in the second case, Mr. Green, or do you need for us to take a short break, or are you going to immediately admit them?
I'm getting ready to admit them now, Your Honor.
All right, thank you.
Counsel is present, Your Honor.
All right, hello, everyone. And again, this is our second matter on the calendar this morning, bar disciplinary matter, in re William Wallace. I thank everyone for your patience. As the court has transitioned to doing remote video conferencing for our oral arguments, we may experience some technical glitches despite our efforts to practice with the technology. So I appreciate everyone's patience as we proceed today. May I ask counsel if you're ready to proceed, and if so, if you could start by introducing yourselves.
Hamilton Fox, the Office of Disciplinary Counsel.
All right, hello, Mr. Fox, how are you today?
Good morning, Your Honor. Eric Yaffe, together with Frank Sciramano for appellant.
All righty, how are you, Mr. Yaffe?
Very well.
Okay, Mr. Fox, are you ready to proceed?
I believe Mr. Yaffe is.
Mr. Yaffe is ready to proceed. I'm sorry. You all are reversed in your positions on my screen as from the positions that you would normally be seated in. So Mr. Yaffe, would you like to reserve any of your time for rebuttal this morning?
Yes, Your Honor, 3 minutes if I may.
Okay, thank you. You can proceed.
May it please the court, my name is Eric Yaffe, and together with Frank Sciramamano, I am representing respondent appellant William Wallace. The board erred in finding that Mr. Wallace testified falsely on one issue, that he violated Rule 1.16D, and that he should be sanctioned for a period of 30 days. We would ask the court to reject the board's finding and to find that Mr. Wallace did not violate any of the rules and that he should be not sanctioned for any period whatsoever. There are 3 issues that I'd like to address with the court this morning. The first issue is the credibility issue because it goes to the heart of the board's determination and sanction. The second issue that I would like to address is Rule 1.16D, which the board found that Mr. Wallace had violated. And the third issue is the issue of sanction. First, with respect to credibility, the board, as I mentioned, found that Mr. Wallace testified falsely on one issue, and that relates to what is known as the Jeannie Feiger memorandum. Mr. Wallace, the board said, testified falsely when he stated that he had done research on Rule 27 of the Federal Rules of Civil Procedure and provided it to Ms. Feiger, and that she fed it back to him. I will tell the court that there is indisputable evidence in the record that Mr. Wallace testified truthfully. And I would ask the court to look at RX 125, which is part of index number 9. In that particular exhibit, there is a case called Liquor Salesman Union that Mr. Wallace provided to Ms. Feiger on or about March 9th of 2015. And that shortly thereafter, on I believe around March 15th or 19th of 2015, Ms. Feiger provided her memorandum to Mr. Wallace. In that memorandum on page 2, she cites explicitly to the case that Mr. Wallace had provided to her, Liquor Salesman Union. So Mr. Wallace testified truthfully that he had passed this case to her, she had passed by him. There's other record evidence as well, and I would point to one other thing, and that is RX 42, which is Mr. Wallace's memorandum on Rule 27. He had done the research on that issue. So I think the record shows that Mr. Wallace testified truthfully on this issue. In fact, there is no clear evidence, no credible evidence, no substantial evidence, no evidence whatsoever that shows that Mr. Wallace testified falsely, and the only corroborating evidence in the record shows that he testified truthfully. And this is critically important because the board's basis for their finding that Mr. Wallace should be sanctioned for 30 days based upon the aggravating factor of this one issue that he had allegedly testified falsely. And that finding is simply incorrect, even without looking at the supplementation of the record material that we had suggested the board review, but they rejected. The second issue, Your Honors, is Rule 1.16D. And of course, that rule indicates that an attorney must take reasonably practicable steps upon the termination of the relationship between the attorney and client to ensure that his or her—
Mr. Jaffe, if I may interrupt, I just, before you go on to the second issue, I wanted to ask you a couple questions about the board's determination. As you know, the hearing committee found 4 instances where Mr. Wallace had falsely testified to the hearing committee, and 4 additional instances where his testimony lacked candor. Now, the board, in reviewing these instances, essentially reversed the hearing committee on 3 of the false testimony claims that they found, and on all of the lack of candor claims, leaving us only with the false testimony question about Mr. Wallace's statements regarding Ms. Jeannie Feiger. You know, the statement that everyone is sort of hanging their hat on here is the quote from Mr. Wallace: "I fed to Jeannie Feiger and she fed it back to me, the research." And it seems to me that that's open to a lot of different interpretations. So tell me why the board's conclusion and finding that it did constitute false testimony was improper, or clearly erroneous, I guess, or not supported by substantial evidence. I'm trying to hone in on our standard here.
I understand, Your Honor. First of all, other than the statement itself, there is no corroboration to establish that Mr. Wallace failed to feed information to Ms. Feiger concerning Rule 27, which concerns pre-complaint discovery. The only evidence in the record on this issue, and I think it's indisputable, and it's actually in the record but wasn't mentioned before, is RX 125. It's a fast case that says sent by William Wallace to Jeannie Feiger, dated March 9, 2015. That is the liquor salesman case. And then Ms. Feiger cites that case on page 2 of her memorandum, which is RX 49. That alone shows Mr. Wallace fed information to Ms. Feiger and she sent it back to him. You also have the other piece of information, which is RX 42, which shows—
Well, when you say fed information, I guess I understand the crux of your argument to say that based on what's in the record, it was not unreasonable and it was not false for Mr. Wallace to say, look, I did some preliminary research or some preliminary looking at this issue. I need you to do further research, right? And then we know that Miss Jeannie Feiger was paid $5,000 for that additional research she did. I guess what seemed to stick with the commission, the hearing committee, and with the board was if, I guess the question in their mind, I presume, was if Mr. Wallace had done some preliminary research, where was it? And why would he still need to pay Ms. Feiger $5,000 to do research on something he had already done some preliminary research on?
Well, Your Honor, I think that there's no question that in private practice, people will provide information to others who are doing research for them as a starting point on your research, and then they might do research for you. And I think the critical issue here, Your Honor, is
Was that argument made to the hearing committee and to the board, what you just said, which strikes me as reasonable?
Yes, it was, Your Honor. It was made in the briefing to, I know, the board. I don't recall about whether it was made to the hearing committee, but certainly to the board, we made that argument. But beyond that, Your Honor, I think that the issue, of course, the standard is clear and convincing evidence and substantial evidence in the record. And the only evidence in the record is that Mr. Wallace provided at least this one case to Ms. Feiger, and that she, in fact, cited it and sent it back to him, which is exactly how he testified. So I think the board, I think no one saw that, unfortunately. It's in the record. And it establishes beyond any doubt that Mr. Wallace was truthful in his testimony. And I think the fact that there is no evidence to establish beyond the supposition that Mr. Wallace testified falsely, beyond speculation that why would he, send information to them, there isn't any record evidence to establish that he testified falsely, never, let alone substantial evidence in the record. So I think it's indisputable, quite frankly, Your Honor, if you really look at the record closely, that Mr. Wallace testified truthfully. Not only is it a question of that there's not enough evidence, but there is actually evidence showing that he testified truthfully in the record. So that is our position, Your Honor.
Thank you.
As to 1.16D, the board found that Mr. Wallace violated that provision by not answering questions of the client's post-termination about what his fee should be. Of course, this was a contingency fee matter. And there are a couple of problems we believe with the board's finding. Mr. Wallace, in fact, stated to Mr. Hagan's successor counsel that he's looking for a percentage of his fee. Now, he also said that it might be 34%, but at the time, Mr. Wallace couldn't be more clear because, as the case law recognizes, if the day after the case was settled, Mr. Wallace would be entitled to 34%. If successor counsel did a lot of work over a long period of time, then perhaps and then got a successful result for the client, then perhaps Mr. Wallace would only be entitled to 1% or 2% or 5% or 10%. But Mr. Wallace wasn't in a position to answer with precision. So the issue here became, well, he should have said something. There was a lack of communication there. And that in the board's view, affected their ability to evaluate their risk of changing counsel. But if you look at the record, Mr. Wallace actually terminated the relationship through letters once they asked him to be terminated. He waived the 20-day notice provision in his engagement letters before termination, and he provided them with all of their money back. He did everything he was supposed to do and discussed the issue in part with Mr. Hagan, and they got counsel immediately. They were not prejudiced whatsoever in this case.
They
But
did.
I'm sorry, go ahead, Judge Thompson.
But at least one of the clients, according to the record, came back to your client and said, well, if I can't know that I'm not going to have to pay double 34%, you need to keep representing me. So there does seem to be evidence that the clients were left to struggle with this issue. And had your client said what he could say, had he said what you just said, I can't tell you what my fee would be because I don't know where this case is going. It might settle tomorrow. It might not. Why didn't he have an obligation at least to do that? And why was his silence not a violation of that obligation?
So, Your Honor, on May 26th of 2015, Ray Lorenz said that if you are going to take a 34% fee, then perhaps I would like you to represent me. But 20 days earlier, on May 6th, she had already said, I'm terminating the relationship and I'm hiring Mr. Hagan. So now she has Mr. Hagan, who's a competent lawyer, and the rules around the country are very similar in this vein. She can get advice from him. This is post-termination. And while maybe Mr. Wallace, it would have been nice for Mr. Wallace to have been clear in his comments or to have gotten back to his clients more quickly, the fact of the matter is that they all stayed with Mr. Hagan. They kept going, and they went until the next year. And in the meantime, Mr. Wallace, when he was confronted with this issue by Ms. Herman of Disciplinary Counsel, said that he was only seeking what would be reasonable, and that would be a quantum merit theory.
Well, but Mr. Jaffe, he didn't say that right away. I mean, I think if Mr. Wallace had said that initially when asked by the new lawyer that some of the clients had retained, if he had simply said, I wasn't sure, I don't know what my, what type of fee I'm going to ask, that essentially is quantum merit. He could have said that initially much earlier, and then the clients would have known for certain and not had to speculate along with their new counsel as to whether there might be a double contingency fee, one owed to Mr. Wallace, one owed to their new counsel, or whether he was going to seek, he being Mr. Wallace, was going to seek to recover in quantum merit.
Well, I think, Your Honor, there's no question Mr. Wallace did not say more to his clients. I do think he did communicate with Mr. Hagan. I think from the communications with Mr. Hagan, it was pretty clear that Mr. Wallace was looking for a reasonable fee at the end of the day. But I would say that
well, you say, Mr. Jaffe, you say that, but right at the beginning, when he sends the engagement letters, he specifically points to the contingent, the 34% contingent fee paragraph, right?
yes.
And then some subsequent communication where he says, you can say that I'm not entitled to that. And, you know, I can say something about the moon being made of cheese. You know, it's like he's mentioning the 34%. And then there's just this silence when he's asked repeatedly by successor counsel and by his former clients, where are you on this? Because we're trying to figure things out. And it almost sounds more like, you know, of course, we don't know what's happening in his mind, but it doesn't sound like he's not responding because he's not entirely sure, but it's almost like, Pete, you know, I'm not going to help you.
Well, I think Judge Ruiz, he was deferring to Mr. Hagan, and perhaps you could say that maybe he shouldn't have, but Mr. Hagan is also an attorney who's dealing with the contingency fee issue and is also in a position to advise the clients. And I guess the question becomes, was Mr. Wallace's lack of communicating directly with his clients an issue? But even if the court were to find that there were a 1.16D violation, I would mention that we're not aware of any instance where just with a 1.16D, if you agree with that there's no aggravated circumstance here at the end of the day, has there been a suspension? And I think this would fall more within the informal admonitions in all those cases that we cite to the court, especially in light of Mr. Wallace's 40-year exemplary record in our community and having no disciplinary issues at all. The mere fact of one instance where he didn't communicate, in an instance in the end where there was no prejudice to the client, we believe should not be a violation or sanctionable misconduct, or that a suspension certainly should be imposed.
Well, that depends also on the first point you spoke about, which had to do with whether or not there is substantial evidence to support that he testified falsely about the FIGER memorandum, right? Because the board placed significance on that in terms of the suspension sanction.
I would agree with you, Judge Ruiz, and I think if you look at the record, you will see that Mr. Wallace did testify truthfully with respect to that.
All right, Mr. Jaffe, we'll reserve some time for you for rebuttal and hear now from disciplinary counsel, Mr. Fox.
And please the court, Your Honor, Hamilton Fox, the Office of Disciplinary Counsel. This case affords the court the opportunity to clarify the role of the board in reviewing hearing committee report credibility findings with respect to respondents. It is our position that the only de novo review that the board should take of a hearing committee's credibility findings is whether the testimony that the hearing committee found to be false was deliberately false, was intentionally false. In the words of the Bradley case, did he give sanctionable false testimony?
Well, Mr. Fox, let me press you a little bit on that point. I think if I understand Mr. Jaffe's argument, and as I understand the record, there is evidence in the record that calls into question the hearing committee's finding that Mr. Wallace testified falsely with respect to Jeannie Feiger's work. The board, you don't mean to suggest, do you, that the board has to turn a blind eye to the actual record upon which the hearing committee, at least in part, based its findings? I understand the role of the hearing committee and who sees the witness and has the witness before it. I understand their role in assessing credibility, but they also have a full record, factual record. And the board in its review, if they see that a finding appears not to be supported by substantial evidence in the record, and here, according to Mr. Jaffe, he's pointed us to documents and evidence in the record that perhaps call into question the basis, the factual basis for the board's credibility determination. Seems to me that's precisely within the role of the board to examine that. And if they determine that there wasn't substantial evidence supporting the underlying fact on which the credibility is partially based, that they can come to a different conclusion, as they did here in 3 of the 4 instances.
I am not quibbling with what Your Honor says in that regard. What the court has said, and what I think Your Honor just said, was there has to be substantial evidence in the record, and that the court has said has to be more than a scintilla. But what this board did in this particular case was to go way beyond that. And I think the clearest example of that is the testimony that Mr. Wallace gave at the hearing as to his reason for releasing his claims against all his former clients, except for the 4 who had filed a complaint with disciplinary counsel and who had fired him. He released everybody else. And what is it? His reason that he gave at the hearing was that he wanted to maintain the status quo. He didn't want to do anything that would interfere with the disciplinary system. The hearing committee that heard that testimony found that testimony to be false. And it found it for a number of reasons. First, it found that Mr. Wallace had given a bunch of other explanations contemporaneously as to the reason for not releasing or for what he was doing. For example, after the settlement first came in, he was contacted by Mr. Hagan, the California lawyer. And he said, okay, Mr. Hagan says, okay, what is your claim? And Mr. Wallace says, I'm not going to tell you. The clients can make me an offer. Well, that's not somebody who's trying to keep the status quo. That's somebody who's indicating a willingness to settle. When they hired Mr. Clark here in the District of Columbia, he told Mr. Clark that he was willing to mediate, but he wouldn't specify what his claim was. Then he changed the story again and told Mr. Clark, I'm not going to file for arbitration as long as these clients are maintaining disciplinary complaints against him. Crucially, he never, ever contemporaneously in 2016 said to anybody that the reason I'm not going to settle with these clients at this point is because I want to maintain the status quo because I think it might affect the disciplinary system. In fact, he released another client, Mr. Ruppel, who had also filed a disciplinary complaint against him, but who is distinguished from these 4 clients in that Mr. Ruppel hadn't fired Mr. Wallace. Mr. Wallace had fired Mr. Ruppel as a client. And the hearing committee, in rejecting that testimony, specifically referred to Mr. Wallace's demeanor, his shifting stories and his demeanor. And in the other cases, for example, Judge Thompson's recent opinion in the Ton case and in the Anderson case, decided a number of years ago, the court has always has pointed out that when they have overturned these sorts of determinations, it's when the hearing committee is not basing its determination on demeanor. And here they explicitly did. And then you take that in the context of the other false testimony that Mr. Wallace gave, as Your Honor pointed out in your question to Mr. Yaffe, 4 instances of false testimony and 4 other lesser instances. What is the evidence that requires that be overturned? Why is there no deference to the finder of fact? And what the board said was, well, it's possible that a lawyer would want to maintain the status quo in the context of disciplinary proceedings. And indeed, the board came up with better reasons for doing it than Mr. Wallace did when he testified. But that is not what the board is supposed to do. The board is supposed to defer to the hearing committee if there is sufficient evidence in the record. And the board itself, in this specific finding, which it overturned, said, we concede that there's evidence that goes the other way. So that's the classic situation where the board and the court should defer to the hearing committee as the finder of fact.
Can you, Mr. Fox, can you apply those standards you just enunciated with respect to the testimony concerning the memorandum?
Sure. Let me address that. First of all, the argument that the only thing Mr. Wallace said that I fed to Ms. Feiger was the research with respect to the ability to take pre-judgment discovery. That's a recent refinement. That's not the way the hearing committee read the testimony. And frankly, that's not the argument that Mr. Wallace initially made to the board. If you go back and look at the hearing committee's report, it's in footnote 9 where they discuss this particular the Feiger memorandum. And they cite in footnote 9 testimony of Mr. Wallace that runs from page 527 to 531. And they also cite as false testimony, not only his testimony that he fed the research to Ms. Feiger, but he said he fed it to her because he wanted to get her invested in the case so that possibly she could be involved in the California proceedings. And that's what the hearing committee found to be false. Now, Mr. Wallace argues, well, I was really only talking about this one specific area of research. But that's not the argument he made to the board. If you go back and look at Mr. Yaffe's brief to the board, what he says is, as an example of the research that I did, and he cites to one of the exhibits that Mr. Yaffe referred to a moment ago, I think it's exhibit 42, which is a undated research memorandum on Mr. Wallace's stationery, letterhead, that discusses pre-filing discovery. And that was cited as an example of some of the things that Mr. Wallace might have done to assist Ms. Feiger. But it was never the specific argument that is being made now. The only thing I was testifying to that I gave to Ms. Feiger was the this one bit of research.
But that's a question of what the record shows, right? This is with respect to this particular finding. Did the hearing committee say that it was based in part on demeanor?
I think the hearing, my recollection, Judge Ruiz, is that the discussion of demeanor was in the context of the previous finding that I just talked about.
That's what I thought. Yeah, thank you.
But again, I'll go back to the Tunn opinion. The court said in the Tunn opinion that while in that case there was no indication that the hearing committee was basing its decision on demeanor, it then went on, I think, in the very next sentence to say, but we're not requiring you in each instance, hearing committee, to say it's based on demeanor. And I think it's—
No, but we look at, but I mean, we should look at the basis for the hearing committee's determination. And one of the things was, well, look, if you did the research, why would you pay $5,000 to somebody else if you were going to do everything? And so the hearing committee seemed to be saying, equating the scope of what Mr. Wallace said he did as being congruent with the scope of the memorandum. As I understand the argument, and you've just been referring to it, is that he said, no, I was talking about the pre-filing discovery part of this. And, you know, I just fed her this, gave her this as a start. And then, of course, she took that, but what she produced was broader in scope than just that. And doesn't the record bear that out?
I don't think so. First of all, it's the board that puts the emphasis on the $5,000 that is mentioned in the hearing committee, but that's the crucial determination of the board. If you look at footnote 9 of the hearing committee report again, and I think it's fair to read that as saying that they did interpret Mr. Wallace's testimony as being, he was just limiting what he said he gave Ms. Feiger to this one particular bit of research. And it also cites testimony he gave in which in the context of what they said they didn't believe, that he was trying to get Ms. Feiger invested, I think is the word he used, into the case so that she might participate in it further, I think because she was a member of the California bar and he was not. But frankly, I think in terms of the false testimony that Mr. Wallace gave, the testimony about Ms. Feiger is much less significant than the testimony that he gave about keeping the record in equipoise, and the other three areas in which the hearing committee found he gave, the other two areas in which the hearing committee found he gave false testimony. His false testimony about not receiving the email from Mr. Clark, and his false testimony about—
Mr. Fox, on those two examples, whether the hearing committee found to be false testimony, not receiving or not seeing, I think is what he said in the record, the email from that you just referred to, and wanting to keep the record in equipoise. Those to me seem so fuzzy that it's difficult. It's not like he said today is Wednesday. I mean, I'm sorry, today is Thursday, when in fact today is Wednesday. That is a blatantly false testimony. But when somebody says, I didn't see the email, and the only rebutting evidence was the person who sent the email said it didn't bounce back. Well, I mean, we've had so many technology glitches over the last few days, weeks, on any given day. You know, that doesn't seem to me to be something that is objectively false. I get lots of emails that I don't see. I don't receive lots of emails that people said they sent. So that seems to me to be one of those questions that is not, does not give itself easily to a determination that someone speaking those words is falsely testifying. I mean, if you talk about something like, I paid this person $5,000, and in fact, all the receipts and evidence show it was $3,000, that's something that's easily determined to be false. So I think the reasoning that the board gave when looking at some of these determinations of alleged falsehoods on the part of Mr. Wallace are kind of fuzzy, not completely factual issues.
I take your point about the bounced email, and I'll come back to that. I don't think the first one is fuzzy at all. But the reason I say that is I think you have to look at both of those statements from Mr. Wallace in the context of what was going on. What we were attempting to prove during this hearing, and what the thrust of the cross-examination was that Mr. Wallace retaliated against his former clients who had fired him and who had made claims with the Office of Disciplinary Counsel. And so Mr. Wallace needed to come up with an explanation as to why that wasn't so. And the explanation that he came up with initially was, well, I just wanted to keep everything at equipoise. I wasn't retaliating against these people, despite the fact that he refused to ever tell anybody that his claim was in quantum merit or specify what it was. I wasn't retaliating against these people. I was trying to keep it at equipoise. The question then arises, well, when Mr. Clark sent you an email in which he quoted you as saying, I'm not going to let the claims go against these people because they filed disciplinary complaints against you. Why didn't you respond to that? And Mr. Wallace's only thing he can say is, I didn't see it or get it. Now, that's in the context of a history of refusing to respond to email. When I believe it was Judge Ruiz was asking Mr. Yaffe a moment ago concerning this issue, she pointed out that they continued to send him emails and he never responded to it. That was his modus operandi. And the hearing committee knew that. They heard him testify. They knew in the context of what he was testifying about that he was trying to get away from the obvious import of the evidence that he was retaliating against these four clients. And in that context, they judged his statement that I didn't see this email before. And they found it to be false testimony. And it seems to me it's perfectly appropriate for the finder of fact to hear testimony that could be true and say, no, we don't believe that person. It happens every day in criminal cases where you have
we take your,
Mr. Fox.
I'm sorry, I was going to say, Judge Thompson, you go. I was going to ask Mr. Fox to move to one of the other issues because I know we've taken a lot of his time, unless your question
Can
is
I
about.
follow up? Yes, it is on
Yes.
this one, and I'll try to be quick. I will say that I sort of share your impression that the more troublesome testimony is the testimony about why he released his claims against the other clients, but not the 4 that brought the disciplinary action. I tend to think that if there was false testimony, that's the false testimony. But I really wanted to ask you about something you said earlier when you said that the court needs to provide some guidance about sort of the interpretation of Bradley, I think. Can you read Bradley? I think the phrase in Bradley is sanctionable false testimony. And you said that the only thing that the board reviews de novo is whether the testimony was intentionally or deliberately false. And I realize you were referring to the statement in Bradley, something this court said, but I'm trying to figure out in my own mind why that would be something that the board could review de novo. Why isn't intentionality and deliberateness something that ought to be the province of the hearing committee? Do you think so? I mean, again, I understand you're adhering to Bradley, but what's your view on that?
Well, that is exactly my view, but the problem that I have is Bradley, and to some extent Ton, when you really said the same thing. It seems to me that when a respondent gives false testimony, that's a factor in aggravation. And you said in other contexts that we've got to prove that by clear and convincing evidence. But it's a factor in aggravation, but it's not, it seems to me, a legal conclusion. And if I were writing on a clean slate, I would say that the determination as to whether the testimony was false ought to be the finder of fact, the hearing committee, and that the court and the board ought to defer to it. But the problem I've got is there is that language in Bradley. I frankly would argue it's probably wrongly decided.
That's the problem I had too, Mr. Fox.
But I understand you were on the panel, Judge Thompson. But I
well, I was going to say, yeah.
But you know, factors in aggravation. For example, all the time we see situations where a respondent lacks remorse or doesn't understand the problem with what it was that he did. And the court and the board and so forth take all that into consideration as a factor in aggravation. That's the same thing as giving false testimony at the hearing. I mean, we didn't charge him in advance. We obviously couldn't charge him in advance with giving false testimony at the hearing. But in deciding the sanction, one of the things that you take into consideration is, did he give false testimony at the hearing, or if he gave false testimony at the hearing? And I would suggest that the court perhaps might want to revisit whether or not there should be any de novo review of the credibility determination, provided, of course, there is, as the chief judge said, there has to be some evidence in the record to support it, more than a scintilla. But in this case, with respect to this one item that I think is, and you and I both think is the most significant, the board specifically acknowledged there was evidence in the record. It just reweighed the decision. And to make one last point on this, whether whose job it is here, if in fact the board is going to consider de novo the credibility determinations that the hearing committee makes about a respondent, are we entitled to go to the board and to come to this court when the hearing committee makes a determination that a respondent was credible, and therefore, because of that determination, throws out a claim? Are we to come back and say, well, you court and you board, you should revisit that, because that's a credibility determination made about the respondent, and that's something that should, that you should review de novo.
Isn't that what happened in Anderson?
Well, Anderson, there's a footnote in Anderson where the court says that there was no finding based on demeanor, and it casts doubt on the ability of the board, which bases its authority to make these findings on its own rule 13.6. In that footnote, it casts doubt on whether the board actually has that authority, except to make findings things that the hearing committee didn't mention and that were not part of the record.
In this case, Mr. Fox, this question as to whether there was false testimony or not, in your mind, is that relevant only, not that it's unimportant, on the question of sanction?
Well, I think it's extremely important with respect to sanction. This court decided about 6 weeks ago a case called Wilson. And in that case, the issue was whether Mr. Wilson should get a suspension because of the false testimony he gave. And the board had found that was the dispositive factor, and this court affirmed that finding. And it said, as it's ever said since Cleaver Bascom, that false testimony under oath is something that's not to be tolerated. And in every single instance where there has been a finding of false testimony by a respondent, there has been a suspensionary sanction imposed. So yes.
Now, the reason why I ask, and it's something we still haven't talked about, Rule 1.3 B2, and but the underlying conduct that we've been talking about is the underlying conduct for that violation, right?
Yes.
All right. So does it? But I take it that what matters with respect to the violation is well, does it matter why Mr. Wallace did what he did for purposes of Rule 1.3 B2? In other words, kind of what his intent was.
Well, he has to intentionally prejudice the client.
He has to intentionally, yes, because the rule talks about intentional.
Right.
Yeah, intentionally prejudice or damage.
Right. And of course, this court has said in a different context that, sometimes just not doing anything long enough can be, you can meld into intentionality. That's not what we have here. But I believe.
But intentionality can refer to the act. Is it the intention to prejudice, or is it the intentionally to do something that has the effect of prejudicing?
That may be a distinction without a difference, but I think it's intentionally prejudicing. However, if you do something that's obviously going to prejudice your client, you're pretty much intentionally prejudicing your client. So I think the things in reality kind of fold into one another. Here, the reason I hesitated a little bit when you asked me initially, Judge Ruiz, was it the same thing as the 4 clients that he refused to release? It's a little bit more, because his misconduct occurred in this regard over 2 periods of time. The first period of time was in 2015, and that was when Mr. Hagan was coming into the case, and when the clients and Mr. Hagan were trying to find out what it was that Mr. Wallace was charging. And there, we would submit, in an effort to frustrate their ability to bring on a new lawyer, he wouldn't specify, he wouldn't respond to their questions, he wouldn't say even the words quantum merit never passed his lips. He never said anything. Then the second time is in 2016, after the settlement comes in. And then when he dismisses his claims against everybody but these 4 people who have fired him and complained to disciplinary counsel, then that's a second instance in which he's intentionally prejudicing his clients. Mm-hmm. Now the issue that the board went off on here, of course, was that they said 1.3B3 does not apply if there is no longer an employment relationship. And we submit that it doesn't use the word employment relationship. Words to that effect are used in 1.6 to talk about how the obligation to maintain client confidence continues after the lawyer is terminated, and in 1.16D, which we've been talking about. Both of those rules use something like when the representation is over or when the employment is over.
Well, Mr. Fox, if I may, really the only support that you cite, a disciplinary counsel cite, for why we should support, or we should reject the board's conclusion that this professional relationship does not survive termination is a Nebraska case that's not completely on all fours with what we have here. Seems like we don't have any precedent squarely on point here. So you're asking us to sort of take a bit of a leap here with how we interpret this rule.
I agree that I am, but there are two things that I would say about that. Three things I would say about that. The first is that the word professional relationship must have some meaning. And it doesn't say.
But is it the same meaning as attorney-client privilege or attorney-client relationship?
Well, no, I don't think it does, because I think that you would say, that you'd use the phrase attorney-client. If it was supposed to end when the employment ended, then the rule would say after would say that. It doesn't. It uses the words professional relationship. Second, there's a policy reason for this. The court has said that a lawyer has an absolute right to terminate his client. Client has an absolute right to terminate her lawyer at any time. And you don't want to be in a situation like these clients are in, where you terminate your lawyer and the lawyer retaliates against you.
Well, it's interesting. I think you make a persuasive argument here, because we see it on the front end too, where we've said that even before an attorney-client relationship is formally created, a client may go to an attorney to seek out some preliminary information to determine whether or not they want to retain that lawyer and formally create an attorney-client relationship. Is that another situation where you would see, you would place the attorney's obligations to keep initial information shared with the attorney to determine whether or not you want to engage that attorney? Would that fall into this professional relationship category before there's an official attorney-client relationship?
That's an interesting point that I hadn't thought about, Chief Judge, but I think the answer to that is yes. And I think the rules do explicitly say that if a lawyer interviews a client and the client decides not to hire the lawyer has to maintain those confidence and secrets. And there are elaborate rules. Ways you can isolate that lawyer and so forth if the law firm takes the case on. The last point, though, that I would make about 1.3b3 is it's not just the Nebraska case. There is a New York case. And there is some law in this jurisdiction, which is not the same, but it's about when a lawyer was discharged from a fiduciary capacity. And the court did apply 1.3b3 in that context. So as far as I know, only two courts in the country have taken up this issue: New York, and I think it's the Intermediate Appellate Court in New York, and the Nebraska Supreme Court. And you are absolutely right that the facts of those cases are not that have anything to do with this case. But both of those courts concluded, for the policy reasons that I suggest you should conclude, that you don't let lawyers retaliate against their former client because they got discharged.
Is there any kind of a
that for me, the plain reading of Rule 1.3b is that a lawyer, I think it contemplates that while a lawyer is in a professional relationship with the client on whatever subject he has been engaged for, he ought not to do harm to the client otherwise. So for example, if a lawyer is representing a client in an estate matter, let's just say, for example, because of the importance of trust in the lawyer-client relationship, the lawyer shouldn't turn around and take some kind of harmful action against the client in some other total context. Let's say they're neighbors, and the lawyer shouldn't shouldn't throw stones through the client's window and cause him damage. I'm kind of thinking that's all the rule says. You don't harm your client while he's your client. But when the professional relationship is over, let's say you did represent him in the estate matter, when that relationship is done and over and in the past, there's nothing to stop you from suing the client over, a nuisance he's creating in his house, or if you have an auto accident with the client, you could go after him. And that's why I'm thinking the rule really is confined to while the professional relationship is going on, either as it's starting. But here's what I want to ask you. I've been pondering whether one of the comments to the rule helps us here. There's a comment that says that Rule 1.3 is a rule of general applicability, and it's not meant to enlarge or restrict any specific rules. And then in my mind, the argument you make sort of enlarges Rule 1.16. It kind of adds on to that. I wonder if you've given any thought to that.
I hadn't. Can I just respond to one thing you said first, and I will promise I'll answer your question directly. The situation that you posited about the lawyer who no longer represents the estate and then becomes adverse is, of course, specifically governed by Rule 1.9, which obviously by implication permits that. Now, to answer your question, in this case, I think you could make the argument that the same conduct that violated 1.16D is the conduct that we are citing for the violation of 1.3B3. I'm not sure that's the case that would be the case in every situation. One could think of a situation where Mr. Wallace cooperated fully with new counsel. And incidentally, don't forget that he also didn't, despite the fact his clients requested, didn't provide new counsel with the supposed research and so forth that he had done. But let's suppose he'd done all that. And then, angered by the fact that his clients discharged him, he found some other method to retaliate against him. I would think that if you could link that back to the discharge and the professional relationship, that ought to be a violation of Rule 1.3B3. I'm not coming up with a terrific example as I sit here responding to your question, but I think that there could be circumstances in which that was the case.
I'm sorry, I thought that, and correct me if I'm wrong, that the underlying conduct for 1.16D and the one for the 1.3B2 were different. I thought that the 1.16D underlying conduct had to do with the failure to respond when Mr. Wallace was asked about, well, what is the basis for your claim? How much is your fee? All the rest. And that 1.3B2 violation was based on the failure to release the four who had filed a disciplinary complaint. Am I wrong about that?
Well, you're generally right about that, but I would add the following. The 1.16D initially, when remember there were two times periods here. So you go back to 2015, when he initially asserts his claim against all of his clients, not just these three, after they had discharged him, and won't specify what it is, won't say whether it's quantum error, won't even respond to anybody's calls. I would think that would also be a violation of both rules.
Now, could you, I think one of the things that's difficult here is that, the Nebraska case just says, well, there are some obligations that endure past the termination of attorney-client privilege, confidentiality, certain conflicts that you can't undertake certain actions. it would, I think, be very helpful to have some kind of an analysis that harmonizes some of these rules. And I think Judge Thompson started to do that by referring to that specific comment number 10, that about it's a rule of general applicability. But for example, if you look at 116D, there the obligation is to take steps to protect a client's interest in the process of, disengagement, right? But it's to protect. So it's kind of an affirmative obligation to do something. And 1.3B2 is now talking about not intentionally prejudicing or damaging, which obviously is much more reprehensible conduct. And I'm wondering whether by considering that, you could say, well, of course, you have a much higher standard of behavior required with respect to a client, or when you're in the process of disengaging with a client, but that when you're talking about a former client, there is still some obligation, but obviously it is a lesser one, in the sense that all that you're really being prohibited from doing is intentionally prejudicing or harming. I mean, I haven't seen, the two cases, the New York case says nothing in terms of analysis, and Nebraska just mentions these other things, but it just doesn't seem to be any kind of really thoughtful consideration of why this should apply.
Well, I haven't thought it through, but I think what you're saying seems to make a lot of sense, that there is a heightened responsibility of a lawyer to cooperate with new counsel to allow seamless transition for new counsel. And if the lawyer goes to an extremes, which I would suggest Mr. Wallace did here, and actually not only doesn't cooperate, but intentionally tries to prejudice his clients, then that's an additional violation. I would think that makes sense, but that's top of my head. And I'm sure I could articulate it better if I thought about it longer. But I think that your division makes a lot of sense there.
Mr. Fox, we have been very generous with your time for argument, and I don't want Mr. Jaffe to think that we've forgotten about him. And I know that you have reserved some time for, he has reserved some time for a rebuttal. I had just one final brief question about the sanction. If we were to uphold the board's finding of only one incidence of false testimony, and none of the other 3 instances of false testimony or 4 instances of lack of candor, it seems to me that wouldn't that then put the sanction in the realm of a reprimand or informal admonition, which is what I believe Mr. Jaffe argues in providing us with some of those informal admonitions, which a few of them had similar circumstances to this one here, especially when you add to the fact the board's inclusion of a mitigating factor.
I would say that I would refer again to the Wilson case, in which there was a conflict of interest situation, and but where the board said that he gave false testimony under oath, and in every case that a lawyer has done that, the sanction has been a suspension. In this case, I would urge to consider carefully the hearing committee's evaluation of Mr. Wallace's credibility. This was a lawyer who went a lot further than many other lawyers have gone in the number of statements that he made, which the hearing committee found to be false. Hearing committee took a lot of time with it, made specific findings about it. I think they were pretty outraged by it. And a lawyer who does that, who testifies under oath falsely, I'm not saying there's never should be a circumstance where he isn't suspended, but I don't think the court has seen one yet.
Okay, thank you. Mr. Jaffe, thank you for your patience. and we'll give you some additional time for your rebuttal.
Thank you, Your Honor. First, let me address Mr. Fox's last point concerning the hearing committee's findings. The board went through in some detail why the hearing committee's findings were erroneous, and largely in part because there was really no record evidence to support a lot of those findings of false testimony, or they were extremely immaterial and the record just wasn't developed sufficiently to be able to ascertain that there was false testimony. Now, with respect to the issue of what the standard is, which is what Mr. Fox started with in terms of how this court should review credibility determinations, I think there's no question that this is a de novo consideration, because these are ultimate facts that have legal consequences. And there are several cases, as I'm sure the court is aware of, including Bradley, including Downey, including in Ray Allen, which say that when there are legal consequences, such as an aggravated factor that could lead to an enhanced sanction, then of course the court reviews the matter de novo. Mr. Fox is trying to see whether this court might entertain a change in that rule, but this rule has been around for, I think, quite some time. With respect to the specific issue that Mr. Fox raised on credibility as well as substance, I think I need to go into that in some detail. This concerns the issue of alleged retaliation against the 4 individuals who decided to bring disciplinary actions. This is in 2016. The board found, and I think rightly so, that it made sense for Mr. Wallace to try to maintain the status quo. Frankly, I think any lawyer would have, any smart lawyer, under the same circumstances, because he had a situation where if he had in fact agreed to dismiss the claims against those 4, issues could have been raised about what he had done in 2015, why he was seeking a fee. There are certainly a lot of things that he had to consider from a legal perspective, and it made a lot of sense for him to do that. And the board found, and I think again correctly so, that it was simply speculation that Mr. Wallace was falsely testifying when he said that the reason was that he let everybody else go, so to speak, as opposed to these 4, was because he wanted to maintain the status quo. Now, Mr. Fox says, well, but there was inconsistent testimony because he at one point wanted to bring an ACAB action, so to speak, but he had the absolute right to do that. He had engagement letters with each of these people individually, and he had a contractual right, if he believed that he had a right to some fee above 0, which the board said, of course he did, because he did a fair amount of work. He had the absolute right to potentially seek arbitration. Now, in the end, he decided not to, but that is part of the status quo. The engagement letters are the status quo. So his testimony was fairly consistent, and at no point in time is there any testimony, any document, any evidence, let alone substantial evidence, that suggests that he did this for retaliatory purposes. In essence, the hearing committee just decided that was his reason on their own, and the board rightly rejected that. To say that someone is testifying falsely is a very big deal. And I think what the problem the hearing committee found here is they were trying to kind of guess along the way as to whether Mr. Wallace was telling the truth on an issue or wasn't, without even developing the record and without substantial evidence. And it infected the entirety of the hearing committee's findings, including sanction. When you find that someone, and find erroneously, that someone testified falsely on 10 occasions and you're just wrong, but you're going to be infected by that. And certainly we believe that's what happened to the hearing committee here. I'd like to address the 1.3b2 issue if I could for a moment or two. So with respect to 1.3b2, there's no question that the language of that says specifically it's actions taken to prejudice the client intentionally so during the course of the professional relationship. Now, the professional relationship ended in 2015. The disciplinary council says that a year later, that was violated, presumably intentionally, by retaliation. And we would suggest that it's just not the way 1.3b2 should be read. First of all, there are several other instances where the drafters indicate that a lawyer's responsibilities continue after the professional relationship ends. 1.6G, the attorney-client relationship continues, and you have to maintain confidentiality of those conversations or communications forever. With respect to 1.9, if there is a conflict of interest, if you've represented someone, and then later, after the relationship ends, you want to represent them in someone else in the same action, you can't do it. It's against the rule, even though the relationship has ended. 1.16D as well. So we have, which deals with post-termination issues. So it would be very easy for the drafters to say that this continues after the relationship ends, if that's what they wanted to do, but they didn't. And in fact, the case that Mr. Fox cites in DC is, I believe, the Mabry case. And in the Mabry case, it related to a misappropriation by a personal representative. But in that case, there was no discussion of the issue of whether 1.3b2 continues after the professional relationship ends. In fact, there was a lot of activity that occurred during the relationship that formed the basis for the 1.3b2 violation. And so that case doesn't really apply whatsoever. I think here, Your Honors, we have a situation where the hearing committee really went way too far. And the board recognized that, and appropriately so, cut the hearing committee back. And they found still one incident. They said there's enough evidence of false testimony, but frankly, they did just get that wrong. And I think when you look back at the record, you'll see the corroboration that I mentioned that connects very well with the testimony of Mr. Wallace, and that he absolutely testified truthfully there. And with respect to the issue of 1.16D, again, we can argue over this, but we're really talking about maybe a mistake concerning communication, but certainly nothing that would ever arise to the level of the most serious thing this court could possibly do, which is to suspend someone from the practice of law, especially someone who has a really exemplary record over 40 years, as Mr. Wallace does. So we would respectfully suggest to the court that after looking at the record and after looking at the erroneous credibility determinations, that the court find that Mr. Wallace really has not violated any of the rules and that he should not be sanctioned. But if you do find a 1.16D violation, we would ask respectfully that you find only informal admonition. Thank you.
All right, I'd like to thank both counsel for your arguments today and for your briefs and submissions and for your willingness to work with us in this new technology of trying to make sure that we can go forward with the oral arguments and business of the court remotely during this COVID-19 health emergency. So with that, we stand adjourned. Thank you all.
Thank you, Your Honor.
This court is now adjourned.